For pronouncement of judgment, item 21 to 23.
Writ appeals are allowed. Impugned judgment of the learned single judge set aside.
very অলপ correction আছে।
Item number 24 and 25.
Both the writ appeals dismissed.
That's the given. 1 to 8. May I please, Lord? Milord, item number 7, Milord, may kindly be taken up in the next week, Milord. Because Milord, senior counsel, Milord, Arpit Kakoti will address the matter, Milord. He is out of station for personal inconvenience.
At the request and consent of the petitioner, just after 2 weeks.
Oblige, sir.
Made will option. Malo item number 8, the correction was made, Malo, today is come. And the matter was to be argued by one senior lawyer from Supreme Court, Malo, Shobha Gupta. But link was also sent, but she had some difficulty today. Can it be one next week, Malo?
The request and consent for the petitioner, just after a week.
May it please your lordship. My lord, with the consent from the counsel of the other side, I beg to mention item number 10 on behalf of Advocate General Nagaland, who is indisposed.
My Lord,
May I pray?
I have an objection because the first thing is they have not taken the consent of me. Respondent number 6. The division bench order is affecting me. They have got a stay order since 7/9/2022. And the petitioners have challenged the virus of the act, which is on treat. It is not presentable because of the constitutional bench judgment of Supreme Court. My Lord, let the matter be fixed on a particular next week because
My lord,
adverse orders because the interim protection is in their favor.
We have noted your objection.
I have my lord. I pray, my lord, that the matter may be fixed, yes, but my lord, after the Bihu vacation on 23rd of April, my lord,
Is
I have
having
taken the
serious
consent.
objection. He's
No.
having
He is-
Bihu
he-
vacation.
My lord,
It's
he
too long, man.
is the respondent side, my lord. He is also.
Order is
responsible.
against me.
Right, my lord.
Order is affecting him. And if he's objecting, then
I told him, I'm sorry, I could not contact him and give the information to him for that. He is
He can appear to
indisposed, my
DC
lord.
also.
list this matter on 4th of April.
My lord.
4th of April, Mr. Mishra has some difficulty, my lord. He is for the petitioner, my lord.
My lord,
On 27th or
in that case, my lord, let me be allowed because I have filed an application for vacation of the stay. My lord, let me be liberty.
That application is,
No, that application was been withdrawn because the assurance was given that we will be disposing of this matter.
who has given this?
All the stakeholders, my lord. It was filed in Kohima.
Just for the state, us to decide to dispose of who are these persons.
My lord,
They are going to dispose of, you are agreeing to it, get the disposal from them. Once you have moved an application and
My lord,
withdrawn.
I moved an application for under Article 226(3), the stay
you
order,
have Withdrawn that,
my lord.
then we'll fix it on 5th of April.
My lord.
Obviously.
On the concept of the petitioner seeks urgent.
my lord, it's respondent statement.
State
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 response.
respondent seeks adjournment. However, the counsel for the respondent number 6 has serious objections. Full stop. List this matter on 4th of April,
5th of April. 4th, we have some difficulty, 5th of April.
5th of April.
5th of April.
Actually, my lord, my humble prayer, because the Advocate General is indisposed, my lord. That
No,
is
it
why
may
he
be
raised for a
once we
date
have-
on the.
Once we have decided, we'll hear it on 5th of April. If any
Lodge.
difficulty, we'll consider
Lodge.
it and otherwise we'll hear the matter.
Lordship, I'm okay.
We are adjourning this matter with this understanding that we are going to hear this matter.
My lord,
On 5th of April, make your alternate arrangement if
lord.
arguing advocate is not available.
lordship.
In fact, there is a direction from the honorable court that since the challenge to the constitutionality of the act is there, the learned advocate general should be present.
Whatever it may be, then ask the advocate general to remain adjourned.
Oblige, your lord.
Obliged.
Wait, your lordship. Lordship, I beg to mention item number 13, my lord. The
Yes.
counsel for the petitioner has some medical difficulty, my lord.
Have you informed the other side?
Yes, my lord.
Are you sure?
Yes, my lord. We have.
All the respondents?
Yes, my lord.
And the request of the learned concept of that. Appellant,
My lord.
list after 4 weeks.
My lord. Deeply. understood.
May I please, your lordship? Lordship, I beg to mention item number 9, lordship, on behalf of the appellant, lordship. We have some personal difficulty, lordship. We have taken consent also, lordship.
And for the respondents, lordship.
No objection. And the request of learned concept of the appellant list after 4 weeks.
Lordship, it may be fixed on April, lordship, second week if possible, lordship. April second week, lordship.
Any date after Bihu vacation. Fix that.
Bless, madam.
Wait, please, your lordship. Lordship, I beg to mention item number 19, lordship.
Yeah.
Lordship, I am from for the respondents.
Yes, what do you want?
Lordship, this matter may kindly taken up on 4th of April, lordship.
Who is from the other side?
I am for the respondents.
Do you have any objection?
No.
Just after 3 weeks.
Lordship, can a date may be fixed?
It after 3 weeks and
Obliged. Obliged. Lordship, interim order is there, lordship.
in order if I need to continue till next week.
Obliged.
My lord, I am praying for listing this repeal, my lord. I have filed it yesterday, but I have some urgency. Can it be taken up day after tomorrow, my lord?
Tomorrow,
You have to.
day after tomorrow.
My lord.
My lord, I have similar prayer, but it may can be listed tomorrow because last date is 31st of March.
31st of March.
The 31st of March, 2024.
Yeah, that's right. But day after tomorrow, what is the date? It is not 41st of March. 14th March.
Thing is that the
Day
time is
after
after
tomorrow.
tomorrow, I know.
Day after tomorrow.
Yeah.
Not tomorrow.
We have listing for matrimonial arrangement, my lord. Last posted on 24/1/23. Let's fix a convenience there.
Next week, whatever day.
Yeah.
May I please your lordship. Lordship, I beg to mention for listing lordship, a read petition lordship.
Writ petition.
Read petition lordship. Matter regarding the Honorable Armed Force Tribunal rejected the bail petition of the petitioner, and so he filed the bail. Praying for bail lordship.
Bail petition.
This is read petition lordship, but Armed Force Tribunal rejected his bail lordship.
Bail.
Yes.
Court martial. Court martial proceedings were.
Yes, lordship. Yes, lordship. Court martial proceeding lordship.
Next week.
Obliged.
Lordship, sorry for the inconvenience, lordship. Item 9, lordship, there is interim lordship. That may be continue, lordship.
Tell them already, continue till next week.
Obliged, madam.
Daily list for orders item 1.
Look, this is basically with regard to construction of a road connecting Silchar, Harangajao and Haflong. This honorable court, my lord, is basically monitoring the progress of the work because this project initially started in the year 1999. Thereafter, it was stopped. Several contracts. Now they are going on, my lord.
19% completed one.
No, right now 19%.
What is this pace?
My lord.
What is the pace of completing the work? 1999.
No, because this matter, my lord.
19% of the work.
Yes, no, what about my lord? This matter, this route was been initially given contractor, there's a lot of different, they have failed, 3 contractors have been changed. Thereafter now, this due to to PIL, this is now progressive we are playing. Earlier occasion, we have filed that what are the progress is to be furnished. Accordingly, you are furnishing progress.
Yeah.
Earlier status also we are giving that 10 kilometers will be completed by 31st March, my lord. Now, that is our target. Already been a lot.
Total length of the road is?
23 points on my lord. The PWD other part is going on. But initially we have taken consideration 10 kilometers will be completed by 31st. Thereafter again will be completing because full construction is going on, my lord. On last occasion also we have given the progress. Now on as per order of this honorable con 5/2024, we supposed to give up to 27 of this one, 27 February of 2024 progress. I filed on 29th as list case was not, affidavit was not before your lordship. That is why today it has been fixed. Now it is in progress already been shown, my lord, that we are showing in addition. Then target to length target 31st March, 10 kilometers by 31st March, that 10 kilometers. That is now this one. These earlier litigations, due to this only your lordship should please do monitoring this case now further. And we are fully working. Day and night they are working, my lord. Construction is going on. Now we are giving roadmap also. Construction photograph also, my lord. We have to complete, my lord. We are full sync.
Just a minute.
99 guy kill with that. Okay, so yes. This part is over. Major part over. 99 party. The judge vote is monitoring. Then on the video something. Too late. I mean.
They want to solve it.
Pursuant to the direction given by this court. On 5/2/2024. The council for the NHAI has furnished the progress report to the project director.
To the chairman, affidavit shown
By the chairman.
affidavit filed on behalf of respondent number 2 chairman. He is the project director, but the affidavit is filed on behalf of the chair.
On behalf of.
Hmm.
Can I have? Progress report of the project in question on behalf of the respondent number 2 chairman, National Highway Authority of India, through the project director. In the said progress report, the
The affidavit dated 29.
on affidavit dated 29th of Feb 2024. In the said affidavit, details about the progress in the project has been mentioned. Having gone through the affidavit, we find that some progress is there on the part of the national highway in completing the road in question, the highway in question. Full stop. We direct the respondent number 2 NHAI, the chairman NHAI, to submit the further progress report on 3rd of June 2024, indicating the progress in the project from 29th of, indicating the project, indicating the progress, progress in the project from 29th of February 2024 to 30th of May 2024. In between, whatever work you have done, submit the progress report.
Yes. I'll apply.
List on 3rd of June.
Deeply.
Item number 2.
Chairman NHAI over NHAI.
May I please your lordship?
Notes have not been served upon the respondent till date awaited.
Yes, your lordship, lordship.
Await return of notices of the sole respondent for 3 more weeks.
Highly of.
Item 3.
May I please, your lordship? Lordship, on
Yes.
last occasion, my lord had directed the CPWD to inform this court.
Yes.
My lord, the department,
Valuation report, have you prepared that?
my lord, the measurement has been done, my lord. And for
that-
valuation, my lord, certain,
You have already last day also you have selected the measurements.
my lord,
We have already
Lord,
done the measurement. What about the valuation report?
my lord, certain informations are requirement. I am producing 2 communications, my lord.
Permission from whom?
My lord, from the joint secretary come competent authority for land acquisition, Department of Revenue, Kabi Anglong. My lord, my lord, there are 2 letters, my lord. One is the letter dated 25/10/23. My lord, we'll see the last paragraph, my lord. Valuation of the structures present on the site based on the measurement in the above said drawing will be only done after getting the above information. And thereafter, my lord, the
21st of October.
October.
This is October two
My lord.
thousand twenty-three, letter.
My lord, thereafter, my lord, there is another letter dated 21/11/2023. It is by the National Highway Infrastructure Development Corporation to the Joint Secretary, Kala, my lord, Kabi Anglong Autonomous Council, my lord, which has referred to our letter, the CPWD letter, my lord, will see paragraph 2 and 3.
So first information you sought from this general manager IDCL.
Yes, my lord, we have written to NHIDCL. And my
another-
lord, NHIDCL then has written it to the competent authority for, that is Department of Land Revenue, Kabi Anglong Autonomous Council.
And they have not provided.
They have not provided the requisite document, my lord.
Preparing for this NHIDCL and.
I'm for the
Kala,
NHAI, my lord. It's my case, my lord.
Your case,
It's-
why you have not provided the
Well,
information?
we have provided, we have asked this Kala also, my lord, the Kabi Anglong authority also to provide the measurements, my lord. So my contention
Measurements
was,
are already there.
no, my lord,
They,
not,
they,
not,
they
no, no, my
ask
lord,
for drawings
my lord,
in
my-
pages.
my lord, my contention was this, my contention is this, measurement has been taken, whatever needed, my lord, they can do, my lord. But only the report has to be submitted, my lord.
Whatever they can do, but without if they are seeking some information.
They are seeking information not from us, my lords. That information needs to come from the Kabi Anglong authority, not me, my lords.
Who is appearing for that? Why you are not supplying this information? We are lifting it on Monday. देखिए, then council appearing for the CPWD has informed that the valuation of the property could not be completed on account of non-submission of certain documents by the competent authority for land acquisition in bracket Kala, Department of Revenue, Karbi Anglong Autonomous Council, Bipu. Learned council appearing for the Kala has submitted that whatever the information is required will be sent definitely positively within 3 days. List on Monday.
Always.
On that day, council appearing for the Kala may inform this court about the progress.
Always.
Item number 4.
Lordship, in that case, yesterday I have filed our objection in the delay condonation petition, Lordship.
Objection regarding,
Delay condonation, Lordship.
yeah, what is your objection?
Lordship, there is a total 143 days delay, Lordship. Out of that, Lordship, they have not explained the 8 days delay.
104 days, 04 days.
Yes, Lordship, but 40 days delay has not been explained in the delay condonation petition, Lordship.
And we are going to allow this application. You argue on merits.
Lordship, then, Lordship, may. Lordship, then, insert.
The matter comes upon the consideration of the IA number so and so. Report on behalf of the applicants under section 5 of the Limitation Act with the prayer to condone the delay of 104 days in filing the connected appeal. Full stop. Then it counsel appearing for the sole respondent as opposed the application and has argued that the delay has not been satisfactory. The delay has not been satisfactorily explained by the appellant. Having heard the learned counsel for the parties and after going through the contents of the application for delay condonation, we deem it appropriate to condone the delay of 104 days in filing the connected appeal. Hence, the IA number so and so is allowed. The registry is directed to connect to register the connected appeal and listed for admission on 21st of March.
Much obliged.
For admission, item 5 and 6.
Lordship, kindly accommodate for the timing, Lord. For the timing, Lord. Kindly take up of this.
The time.
Lordship.
You have to argue the review.
Yes, Lordship.
Pass it for the time being.
Lordship.
It's Mr. Sagia.
That review and the appeal, Lordship.
Yes,
There is already a stay granted. The matter is, today it is for fresh admission and stay petition. So Lordship, maybe please,
item number 5.
item number 5 and 6.
Last time this, we have adjourned this matter with this understanding that we'll hear the review petition.
In that case, Lordship, let it be taken up tomorrow, Lordship. Because I have scheduled it in that way, Lordship. Even I have just had a discussion with the other side senior counsel also. He is also on leg in some other court and also fix some other matter. I am ready otherwise, Lordship, but it will upset the whole day's program. It will be quite lengthy because there are two petitions. One is content. And we got the impression that the for fresh admission and stay petition in the category, Lordship.
So last time we
No.
deliberated on this.
In
the
fact,
contempt
we have
motion,
argued this matter
we have-
before.
We have stayed the contempt proceedings, but adjourn the matter with this understanding that we'll hear the review petition.
I have no difficulty, but the thing is that, Lordship, we had the impression that for fresh admission and stay, the category, it is not in the, if Lordship is,
Whatever it may be, whatever the category, now you have to argue the review.
let the
petition,
matter come up
whatever they-
tomorrow, Lordship, tomorrow we'll argue. No difficulty, Lordship.
Tomorrow.
Lordship.
And
At top of the
Please.
list also.
And you please, it is not so urgent, sir. You please satisfy us on the point that the learned single judge has allowed the writ petition of the respondent against which the state has not filed any appeal.
Lordship.
Only the respondent number 7, that anti-corruption something.
Yes, Lord.
Society, they have filed the appeal and the appeal got rejected. Now, how the state government can file a review of that division bench order, sir? You have not challenged that order of the learned single judge, you accepted that.
We are about, our appeal was also ready. In the meantime,
Ready or not ready is altogether different.
and single judge's order,
Before the learned single judge, you have supported the case of this private respondent.
all along we supported only for the simple reason that the report of the enquiry officer,
You have to satisfy.
that enquiry
you
officer's
have to
report is totally,
satisfy us regarding the maintainability of the review petition.
Lordship.
On behalf of the
yes,
state.
because we will,
Day after tomorrow.
After tomorrow.
Day after tomorrow.
day after tomorrow, Lordship. Lot of other cases, in fact, that one of the, that caste certificate, one of the MP's case is fixed tomorrow, day after tomorrow.
The cases you will always be busy, Mr. Saikia.
No, I am not busy. That case, because that will, same issue of the, one of the sitting MP is going to contest the election. They have filed a motion yesterday because the second half was not sitting. I have no difficulty with that. Let it be a day after tomorrow,
Yes,
Lordship,
sir.
or Tuesday, Lordship.
Tuesday.
Day after tomorrow.
Tuesday.
Tuesday.
That other issue is also regarding caste certificate.
Whatever may be that, we'll decide on its own merits.
For hearing, item 11 and 12.
Look, Mr. R. Borpujari, he is in the other court now. Kindly take it up after some time now. Mr. Borpujari will come.
Matters, see, we don't have any matters.
If he's on legs on court number 10, Mr. R. Pujari is on legs at court number 10. Should we kindly pass over the matter for some time?
Where is Mr. Arbor Pujari?
Legs on court number 10.
In the first court, he has to be present. Yes, this is not the way. You can't ask the first court to wait on these grounds. There are certain customs and traditions. The bar members are forgetting it.
Just some time.
First court matters cannot wait because the counsel is on legs in another court. Are you not aware of this? You are asking the court headed by the Honorable Chief Justice to wait for the counsel?
This is a.
Jurisdiction exercised in reference to Article 21 of the. I can refer to the mark. 2000 days. Yes, pहले नहीं हुआ था. Process started from flat. So it's fundamental. First court में
First one for the time being. Yes, next.
For hearing, item 14.
Yeah, please, Lordship. Respondents come to pending. Definitely by the, you will bring. This.
None present for the counsel, for the respondent. Mr. Corvi. Yes, next.
Item 15.
Respondents are served, my lord, otherwise, but then not appearing. Earlier also, I think probably on one occasion, they were not there. And otherwise, my lord, the issue relating to this particular cases, a similar case has already been decided by this honorable court. These were cases where, my lord, these people were working as casual workers back in 1998 only. 1998, my lord, they were discharged from service. And the question of
Just a minute. Okay. We can appoint a amicus. वो आया तो आया नहीं आया तो होने वाले एक्सपर्टी करने से क्या आइटम 14 और 15 और प्राइवेट रेस्पोंडेंट्स और काउंसिल को अलग फोन করে পেলে অলপ মাতিব পাৰিব নেকি Mr. Pathak, wait for some time. And
Hello,
Mr. Dev Chaudhary, in your matter also, we'll ask them if they are not appearing, we'll engage amicus curiae and hear the matter on the next week. Because,
Item 15, in my case, my lord, Mr. Gautam Goswami was appearing, but then he, no, 15, I'm referring to 15. 15, Gautam was respondent side. Moto-
Having regard to the subject matter, we are reluctant to pass ex parte orders.
My lord, I understand.
So if the private respondents council don't appear, then we have the option of engaging amicus curiae and
In my case, my lord, the other side's counsel, he has also been now engaged as a counsel by BSNL. Probably that is the reason why. he
that's
cannot
why
appear.
we'll ask him and then
My lord. I'll try to contact myself.
Then, he had made any alternate arrangement, it's okay. If it's not made, then we'll appoint a amicus curiae.
My lord,
just wait for a little.
my lord, I'll try to inquire.
Yes.
Item 16.
May I please, Your Lordship? This repetition is, Lordship, directed against an order passed by the NHAI. Lordship will find the order at page 73. A charge sheet was issued against the respondent. And that was set aside by the learned tribunal on the ground of delay, Lordship. If I may take your Lordship to page 91. What's the coupon? 2013, 6.
That's what, is there a bar under the rules? Is there a bar under the rules that charge sheet disciplinary proceeding cannot be initiated just prior to retirement? There is a provision.
Lordship, disciplinary proceedings normally their disciplinary proceedings should be when the person is within the service, but under the rules, there is also provision for disciplinary proceeding after the person has superannuated. there is a, now here is a case where this person,
Just a minute, Mr. You are appearing for the respondent.
Yes, my lord.
Is there any bar in the service rule that just before, prior to the date of retirement, the charge sheet can't be served? Is there any bar?
That is in the pension rules, my lord. It relates to an incident prior to, if the incident is prior to 4 years.
How those pension rules can be applied, sir?
Well, in
That
the,
after retirement, those came into operation only after superannuation.
no, the submission which my learned friend has made, that even after,
Learned friend, you just satisfy us. Is there any bar?
that,
The relevant rules that before the person who is going to retire soon, no charge sheet can be issued.
no, I have not checked into that angle. Though. I have not checked.
Can't say 4 years inordinate delay of 4 years can't be inordinate delay. And the charges are of giving appointment to the persons who are less meritorious without there being any application filed by them. You appointed them less than 18 years of age person was appointed.
No, there are explanation on those counts, my lord. There are
What
explanations.
the explanation is to be considered by the authority concerned, not by us.
No, my lord, the delay itself is a aspect, my lord, which casts a prejudice on the delinquent.
Delay.
Delay itself is a prejudice.
Their
Is-
case
and
is
more
that
so, more,
they noticed all these irregularities in the year 2011 only. In 2015, they have served you a charge sheet.
therefore, my lord, there is no explanation why there is a delay of 4 years. Because all the decisions that the
This
honorable,
delay of 4 years with reference to what? 4 years since what?
4 years in issuance of charge sheet.
With
Even if-
reference to which date?
even if it is,
4 years since he entered the service or
no,
what?
no,
Then-
4 years since they say that they have come to know. Otherwise, the delay is about 10 years, 5 to 9 years of delay from the date of incident, alleged occurrence. Now, if they say that they have come to know about it only in the year 2011 or 12, even in that case, my lord, there will be a delay of 4 years. Because it all happened with all their concurrences. The appointments that were alleged to have been made in violation of rules.
Discussion. Order appears very perfectly presented.
My lord, basically, my lord, the tribunal has proceeded on the ground of delay. On the ground of delay and more so when there is no explanation. There is absolutely no explanation on this point. Why they took 4 years and just before the day of retirement, one day before his retirement, my lord, the charge sheet was.
Is there any prohibition under the law?
Well, that I'll have to check.
Check it.
In fact, the decision relied upon by the learned tribunal in the case of Chairman Life Insurance Corporation India Limited supports the case of the union.
Well,
There's a
I mean, my
other
lord,
case also of 2013 6 SCC 515.
एक issue याद है. There are judgments that disciplinary proceeding initiate commission are under delay in concluding. Then there are judgments that it affects the rights and but if there is a delay in initiating the department, then it means the tax of that case.
During the pendency of the OA, stay was operating.
Yes, my lord. And my lord,
And when did he retire? Your plan?
it was, retirement was just 4 days after issuance of charge sheet.
Which?
That
year?
was 2015 itself.
And you immediately approach the, this tribunal and tribunal has stayed the proceedings.
Yes. The charge sheet is 20th of February and 24th he retired.
And Mr. Dev Chaudhary, why there was 4 years delay in?
Lordship, I have explained that in paragraph 4 of our petition and paragraph 7.
Paragraph 4 is nothing.
On paragraph 7, Lordship.
7.
And in the backdrop of this, your lordship may also,
Have you taken this ground in the OA?
In the
Reply
views.
to the OA, reply to the OA before the tribunal. You must have filed your response before the tribunal.
Yes,
In the OA.
yes, Lordship.
What was
The
extended at that
response will, Lordship will find at page 65.
65. Written.
And at page 68, Lordship, paragraph 5, Lordship may be pleased to see.
It's not been considered by the tribunal. Terrifying. His pension has been settled. Your client's pension has been settled.
the gratuity and other things were released, but the pension, he was granted the provisional pension.
He's still now, till now, he's receiving provisional pension.
Yes. As per my latest information goes.
But the explanation for delay furnished by the Union of India has not even been discussed by the learned tribunal.
My lord, in the backdrop of this defense, my lord, your lordship will also kindly see page 104, the opinion of the department. Page 104 of your lordship's brief.
Is it binding?
No, I'm not saying binding,
Is it
lord,
binding?
but this was the opinion thought by them, and the ministry had given this opinion.
This appeal is also filed by the Ministry or Bharat Sanchar Nigam? That Union of India has filed this appeal.
Lord, the
There may be opinion of the-
The opinion is not binding.
Ministry of Communications has filed the appeal, but they sought the opinion of the law ministry, and this was the opinion of
That is
the law
also
ministry.
opinion.
The legal opinions are not binding.
No, I'm not saying binding, my lord. Maybe that was the mood prevailing in the department, and therefore, my lord, the department did not think it prudent to
Now
go
they
for.
have changed their moods.
No, that's why, my lord.
Now they have changed their mood.
Now, my lord, that's why, my lord,
Mood is always changing.
that's why, my lord, there is a requirement of finding out the reasons. All the judgments, my lord, that the learned tribunal has considered of the Honorable Supreme Court says that there can be delay, but the delay must be coupled with satisfactory explanation. You say that
The explanation was there. Some explanation was there. This is not at all been dealt with by the learned tribunal. In paragraph 5 of the written statement, they furnish some explanation.
my lord, this paragraph 5 is,
They may have rejected that,
this paragraph
but
5
at
is,
least consideration should be there.
my lord, this paragraph 5 is only pointing around the factum of seeking CVC advice.
Okay.
It does not also say that
Okay,
when the
this
CVC,
paragraph one also,
Prevented the cat to observe this also.
in that case, my lord, your lordship can remand the
And-
matter to the tribunal again for fresh
And-
consideration.
Lordship, the citation relied upon by the union, although cited lordship, it has not been given any credence, lordship. In fact, the law, as it stands today, this particular decision has been followed by another decision of the Supreme Court, and the Supreme Court says it cannot be a blanket order, lordship. The facts of the case has to be seen. And here is a case where, lordship, there are so many illegal appointments.
But it was not illegal appointment, my lord. The appointments can at best be
At least-
termed by
at
them
least-
as irregular.
at
And
least-
none of the appointees have been disturbed by them.
He
There
could
was
have
a
faced-
cadre
He
review.
could have faced the disciplinary proceedings if nothing has come out.
There was a
You
cadre
have-
review done and none of the appointees were disturbed. And it was all done with their concurrence.
You can't take benefit of that, sir.
No,
You
if,
can't take benefit of
no,
that.
if they say that the appointments
You
are,
have committed some irregularity, you have to face the music.
no, if it is an irregularity, then it is one thing, my lord. If it is an illegality, then it becomes misconduct. Unless and until, my lord, it's an illegality, it cannot become a misconduct.
Irregularity is permitted.
Well, I'm not saying permitted, my lord, but my lord, when there, it has to be, when a disciplinary proceeding has to commence against me, my lord, there has to be a prima facie basis that I have committed some misconduct.
Mr. Datta, see, the appointment of the particular person, that is not called into question here. What the authorities are saying is that they are unhappy with the conduct of your client. In the manner in which he has picked and chosen the candidates, wherein candidates with better merit has been ignored for no reason, and a person with 43 point something percent mark has been selected over someone who had 73% above marks. So they feel that by indulging in all these activities, your client is guilty of misconduct. Correct? So this, they are within their rights to do that.
Yes.
And it is for your client to meet the allegation, and then if the inquiry happens, whatever happens. Now, here the only question is the learned tribunal has set aside the charge sheet itself on the ground of inordinate delay. We find that, as my lord, the Honorable Chief Justice has pointed out, we find that the BSNL authorities had in fact offered explanation. The circumstances which has contributed to some delay, that has been explained. So
No, my lord.
unless there is a finding that these explanations are untenable, there can't be a conclusion of inordinate delay. That's what we are trying to point out.
Yes, my lord, that's very good. But your lordship will kindly read the, allow me to read the paragraph 5, my lord. What they say, with regard to the statement so and so, the proposal for disciplinary proceeding was submitted on 29/2/2012. And for the incidents during the period from 2005 to 2010, the incidents are of 2005. They say that they came to know about it in the year 2011. Then what happened between 2011? There is nothing, no disclosure. Then 2012, my lord, they file an application for the CBC approval and all. Memo of charge sheet, and thereafter, for the incidents during the period from 31/12/2005 to 1/4/2010, after thorough examination of relevant records, memo of charges have been issued on 2005. Rule 14 charge sheet under so-and-so rule has been issued against the applicant while he was in service. Now, after they submitted the application on 2012 for CBC approval, what transpired between 2012 and 2015? There is no disclosure.
That is inordinate delay.
That is no disclosure. Well, delay.
That is inordinate delay.
Not only inordinate delay.
So who prevented that cat to at least observe this?
No, if on that count, I have already submitted. There can be a case of remand to the tribunal for fresh consideration on this aspect. But for the purpose of, they cannot now supply a reason after the judgment that these were the.
Is not they have not supplied the reasons for taking any action against you, which initially was not in the order. They have simply explained the delay. It is not the case that they are supplying some reasons which are not in existence at the time or at the time of their defense.
Yes.
That is Mohinder Singh's legal case.
Yes.
You are relying upon that
Yes.
altogether.
Now, therefore, my lord, from 2012 also, if your lordship assumes that they really came to know about it.
And in any case, a charge sheet cannot be quashed on the ground of delay. A departmental proceeding can be quashed. Charge sheet has been quashed here.
My lord, the decisions, my lord, the tribunal has considered in the case, right?
Show us a simple, any observation by the tribunal. In a considered opinion in view of the charge sheet having been served after the inordinate delay of 4 years, satisfaction has not been given. They said inordinate delay for the irregularities, no action of cancellation of appointment has been taken. The charge sheet has been served only before retirement, 4 days before the retirement of the applicant. In view of the allegation of omission, commission stated in the charge sheet, being procedural in nature, thus in view of the law laid down by the Honorable Supreme Court in catena of cases.
No, Lord,
The charge memo is required to set aside. Which
Lord,
catena of decision?
my lord, right from 1990 to Bunny Singh's case, your lordship knows, my lord, the Honorable Supreme Court has laid down this, that on the ground of delay, it can be interfered with.
And this 2013 LIC case?
No, 2013, my lord, the facts are different.
What
Two
facts
thou-
are different?
2013 case, no, my lord, 2013 case, it's a general kind of an observation, my lord. It's a
kind
general
of-
observation, my lord.
Read general kind of operation.
Now, no, my lord, here the specific case was, the,
These are
before,
binding.
no, my lord,
These
before
are not
the,
omitted.
before the honorable tribunal, the specific case was that the incidents occurred, according to them, the incidents occurred in the year 2005 to 2009 or 10. And the charge sheet was issued in the year 2011, sorry, 15. So therefore, there was a
Have
delay.
you- Have you filed any counter that for the first time they noticed about the irregularities in the year 2011?
No, it was their pleading.
Yeah,
It was-
you have countered that, no, it was not 2011, they were aware of this, whatever the irregularities in since
No,
2005.
my submission before the court has been that even if it is assumed that 2011, they came to know about it in the year 2011, then they are required to explain the delay till 2015. If not, I submitted before the court that what prevented them from issuing the charge sheet from 2005 itself?
Can't be
Well,
so long.
they cannot explain, they said that they came to know about it in the year 2015. And today, my lord, the man has returned.
Mr. Datta, do you have any other submission except for delay?
Well, that the Honorable Chief Justice has said regarding the permissibility of issuance just before the eve of retirement, that I'll just check. Your Lordship accommodate me for
I don't think so milega nahi.
3 days. Agar mil jaye.
You think so milega nahi.
Remand is not necessary because this is not an appeal. This is the original petition. This is a writ petition. So we are not exercising appellate jurisdiction.
In that case, Your Lordship can have it anytime on 2nd or 4th of the April or any date convenient.
You want
Your Lordship.
further delay?
No. I just want to satisfy the Honorable Court on that aspect. Well, that is a query fallen from court, so I just want to answer that.
Yes, but you see, this inordinate delay argument, on the face of it, appears to be falling flat because of the reason that we find there is some explanation. And that explanation appears to be reasonable, particularly when if a matter goes up to the Honorable President of India, these are not, you see, matters within their control. So some delay is natural. But this is really not a case of delay of decades where they have set ideal over the matter and have done nothing, thus giving rise to a parallel right of your client. That doesn't appear to be a case projected, nor is there any argument. Now, if you say that at this stage, even if a disciplinary proceeding is initiated, no penalty can be imposed upon your client, that could be a ground we may have to consider. Other than that, very difficult. And we are not exercising appellate jurisdiction. So no question of remand. Please come
The
prepared.
other ground will also come to my side, my lord, because of the.
You have to show that it is barred under the law,
Yes, that's why, my lord.
not
That's
that
why-
it is inconvenient.
No,
It's barred under the law.
There is a bar. That's why.
Show us that. Show us.
Because the pension, because the consequence of the disciplinary proceeding now will be only that they can withhold the pension. Now, if they want to withhold pension, my lord, then the occurrence of the incident has to be at least 4 years before the issuance of charge sheet.
Show us that this is barred.
That's why, my lord, that's why.
Show some law on the next page, on this point.
Yes.
Second appeal में तो सर पूरा रात हो 22 पेज मैटर ऑलरेडी लगा हुआ है.
Second of would be a second.
हो गया.
Photo लग गया.
9th of April.
How late?
Item 14.
Lordship, I'm sorry, I missed this matter today, Lordship.
Are you appearing in this matter?
Lordship,
So what do you want?
Lordship may kindly peruse order dated 7/8/2023, Lordship. Lordship, they, the departmental authorities have granted me promotion in 2011 and I'm claiming it from 2010, Lordship.
Are you appearing in this case?
Lordship,
Then we'll hear the matter.
Lordship may kindly accommodate today, Lordship, because I missed it today. So.
After we,
Lordship,
after, when,
any date convenient.
after due, okay.
Lordship.
The name is there in.
Yes, Lordship, I am there.
But he has been appearing consistently. Somehow
I'm sorry,
maybe he has-
come there next time, yes.
Item 15.
My lord, I could get in touch with the council. They have made some alternative arrangement. Ms. Bandana Devi will be appearing, my lord.
They already made.
My lord, I have made a contact. Because the lead counsel here, my lord, he also has been actually empaneled in BSNL as a counsel. So he has limitations now.
If any other advocate is representing, then they are not supposed to, then will not appoint any amicus curiae.
My lord. Then we've taken up next week, my lord, their request.
Her name is there.
B Devi is already there, my lord.
Okay.
She will be appearing.
Pass over for the day.
Item 17.
May I please, my lords? This is a intra field. May I please, my lords? This is a intra appeal arising from the ensuing judgment that is at page 54, my lords, passed by the single judge of the Honorable High Court of Second. It's a service matter, my lords, and regarding interest seniority, my lords. The substantial question that has been formulated is at page 22, my lords. For my lord's consideration. Well, in this matter, it's a issue of accounts officer. There are two people, recruitment. One is by direct and one is by promotees. The person who has been affected, that is the petitioners. The petitioners were given appointment only in 8/5/2008 as an office-setting capacity from the jury gate to the concerned AO, that is the accounts officer, on an office-setting capacity with a rider that the promotion per se would not be counted in seniority and they have to face a DPC as per Rule 16 of the rules. And therefore, it was very clear that their appointment per se is a temporary post, which cannot be counted for seniority. And subsequently, Rule R7 to 17 is born in cadre by direct recruitment through an SPC examination being conducted, and they were given appointment order through the recommendation of SPC in 2009. Now, they were born in the cadre of substantive capacity only in the Quad 2013 months. So their right per se in the cadre of AO months would start only from 2013. And therefore, Malaj, the issue that was brought before the Red Court, Malaj, was that they had a rider to be counted
as a seniority from the date of officiating capacity. The prayer is not the washing of the seniority list. It's retrospective promotion on from the date of the officiating capacity. If my lords comes to the prayer of the red petition that has been annexed, my lords. It starts at the page 151, my lords. Of the paper book, my lords. My lords has the Honorable Chief Justice, my lords. Let's- Like, that's it. Malad at page 151, Malad, I'm taking my lords to 151. So it's not a categorical case of interstate seniority challenging the seniority list, Malad. They are claiming that they have been marched over, Malad, by the direct recruiting. So therefore, Malad, the previous case which was being, in this case also, Malad, there was inordinate delay, Malad. And the state had categorically raised a point of delay also, Malad, yeah. And that has not been considered, Malad.
You have a list of dates?
Yes, Malad, I can, Malad, may I take the loss to the particular documents if he loss?
Just a minute. For the private contract of the 22, and it is name only the direct recruiting law. And just in brief law, I will just give you a very brief detail of the case.
No, but he's
Malad.
arguing the matter. You can't.
Malad, I can please the list of it, Malad. May I take my loss to the relevant documents, Malad, before I go and thereafter demonstrate the list of dates, Malad, as per the documents itself? If my loss is coming.
You have the list of dates.
Yes, Malad, I've prepared a small list of dates, but it. Okay. Malad, since my lodge is there, Malad. Now, the delay was there, Malaj, and 8/5/2008, when they got officiating, they didn't protest it, them, Malaj. In 2013, Malaj, the second cause, I would say, Malaj, when they were promoted in substantive capacity, they were faced DPC, Malaj. During the DPC also, they didn't object, Malaj. And when my advertisement came for the direct recruiting, Malaj, that was also not challenged. So Malaj may kindly take Malaj, the list of dates which Malaj may consider. I've given the page number, Malaj. The vital would be there was a modification of the cadre on 3/6/2003, Malaj, at page 390, Malaj. And thereafter, Malaj, 3/36/2003, the people were appointed, Malaj. Their appointment is at next page, Malaj. That is at 8/5/2008, 165A, my lord. These are the categories of the people who were given as an officiating category, my lord. And thereafter, my lords, on 2008, my lords, and 21/1/2009 and 31st/1 at item number 19. So that is the day when I was born in the cadre.
Is there any rate of filed on behalf of the private respondents? No. They have accepted that.
Malaj, why we have come is, Malaj, as a state, Malaj, we have been burdened with so many issues, Malaj, because it will open the Pandora's box. If Malaj sees the para 23 of the impugned judgment itself reflects that the respondent 3, 4, 5, 6, who were the senior most to them, Malaj, in this junior level, Malaj, they got promotion in 97 and they became officiating in 2008. They have not challenged, and 23 affirms their appointment.
No, that's not the point. You see, what my lord is pointing it out. That these service matters, these are inter-se claim between the different officials. And this dispute here is essentially one of seniority. Correct? So whether the writ petitioners are to be treated as senior or the respondents 7 to 17 and then 4 to 6 vis-a-vis the petitioners, who is to be treated as senior? So the learned single judges held that the petitioners are to be treated as senior. That judgment verdict has been accepted by the persons who are directly affected by the.
Yeah, yeah. And there also we had filed a detailed concept stating that why we can't, this promotion can't be given to them.
No, challenging means have you challenged the judgment of the learned single judge?
That we.
No, that is challenge means that. Contesting and challenging are two different things.
As per the fact laws, the details which the details is already there. Practically.
No, Mr. Counsel, please try to understand the query. If you have not challenged, and if you have not filed any appeal, means you have not challenged. You must have contested the case in this single bench, but you have not challenged it. So then whatever issues are there, why don't we keep it open and to be decided in an appropriate case?
Why,
State is not aggrieved by that.
The financial implication is there, because they have been given retrospective promotion with all benefits from 8/5/2008 when they were officiating. All benefits, So that is dangerous, It will open a Pandora's box tomorrow. Any officiating, because state is always in difficulty, We come to meet the exigencies officiating capacity. With a rider, then as and when the direct recruiting comes, they spill down. Now we cannot do it because of this judgment, So it's a bar for the state administrative, and for the financial implication, it's larger than the writ, So therefore, I would humbly request, to kindly consider. There's an inordinate delay, which my lords was previously hearing the matter, Here 8 years has gone by, They sleep over their rights, In para 35 of the writ petition, they make a specific petition that they only, after getting the post of substantive capacity in 2013, and they make a representation when the R7 to 17 got the senior post. They also claim seniority. They want to get that post also. And that is how the writ has come. So therefore, today, the writ court, in my humble submission, and with all due respect to the single judge, should have not entertained the writ petition on the qua itself in the ground of limitation. They were barred, and waiver and stopper comes into picture. Why, on 8/5/2008, when they got officiating, they didn't protest it. In 2013, when they went for a DPC for claiming the substantive post, they didn't object it. They faced the DPC knowing very well that the seniority would be counted from the date of substantive post. Now they ate the pie of substantive post and they became to the cadre of AO. And after 6 months, they make a representation, but they come before the writ court in 2016. So therefore, on this ground itself, with all due respect, I would humbly pray, to kindly consider and
Even from red petitioners, you are appearing for the red.
I'm appearing for respondent numbers.
The persons who have filed the red petitions.
Yes.
Is there any stay operating?
There is so I request Manoj to kindly stay the.
No stay is there. till
In
date,
Manoj,
And you
because
have not complied with the order.
please Manoj, because it's a matter which.
And you have not filed any contempt.
Nothing.
I have. Yes,
Everybody is sleeping.
Manoj, kindly.
in this, with regard, since they have not filed any stay application.
We have filed, Manoj.
There is no question of stay of this.
Yes,
Now,
Please Manoj.
the matter is already listed for hearing, are you?
Yes.
Yes.
Are you?
Manoj, may I then proceed Manoj with the matter?
Start.
Or Manoj wants any query? Manoj, therefore Manoj. If my lords kindly considers my list of these Manoj, there are few documents which I would like my lords to kindly consider Manoj. In 3/6/2003, Manoj.
Sound too clearly. What is happening?
I'm so sorry, Manoj, please. No. Manoj, I'm audible now. I think I have used that. I'm so,
You have closed your channel of communication
I'm so sorry, Manoj.
at your cost.
I'm so sorry, Manoj. May I start, Manoj? Manoj, if my lords considers the list of deeds, Manoj, I've just called out yesterday, Manoj, 3/6/2003, Manoj, at page 390 and 391. If my lords comes to, this is the bone of contention from here, it starts, Manoj. Manoj, 3/6/2003, Manoj has that. That is at page, running page 390, Manoj.
Yeah, 391 of the paper book.
390 of the paper book, Manoj, that is 3/6/2003, Manoj has that. It's a notification, Manoj.
This is the dusty notice of the retail bill.
Manoj, I'm so sorry, the paper book is not matching. It's a running page 390, which has been.
Are you referring to 390?
390, Manoj, it's a 3/6/2003 notification of DOP number 14.
सारे तो notices हैं। दिखा दे एक बार। एक बार दिखाई दे उसको। These are all notices connection with retail bill.
Manoj, I tender my apologies, Manoj. This, I think my paper book has been previously, I have been given the brief, Manoj. So 390 last time, this is not the brief.
Get your paper settled. Then argue it out. Otherwise, it's very difficult now.
Yes,
You are
ma'am.
referring to something which is not on record at all. In fact, our paper book in respect of this writ appeal
Please, Manoj.
ends at 310.
Please, Manoj.
Thereafter, no documents are there on record.
Please, Manoj.
Paper book की हालत है सब।
But where is it? On the record?
Please, Manoj.
Actually, yeah. Supreme Court ने टर्म Supreme Court order हाँ Supreme Court ने bench नहीं available हमारी रजिस्ट्री तो प्रॉपर पेपर मुझे लगता है सुप्रीम कोर्ट ने एक बनाया फिर उनका एक अपना जिन्होंने
Well, can I seek for a small passover and just if my records and it is not.
yes
The record is also not with you.
ये बोल सकते हैं कि अगर ये चाहे तो रजिस्ट्री के साथ सॉर्ट आउट करके एजुकेशन लेवल पे then let them make a mention I think तो मुझे बताया काम करने में किसी
ये क्या
हाँ बोल दे उनको बोल दे ना बोल दे
सेंट्रल प्लान और
फिर 2 बजे बताए कि आप बोल दे अच्छा see we understand your outstation councils both sides the problem is these are voluminous records and unless the pagination and other things are sorted out so we propose why don't you the appellants council you can take the help of the registry people and see if the records are in order if not then we sort it out and we can have it on another date convenient to all of you.
Subject to my
You tell us at 2 p.m. what you want and accordingly.
If the, because the paging is not, to the mark, but if, a next date is given so that the final hearing lordship, although I have also prepared my dates and events for your lordship's perusal lordship, but I've also marked as per the numbering out here, so it may not tally with lordship.
All right. So could you agree on a date after 2nd, 3rd week of April?
We have already taken.
Can it be on 26th subject? 26th April, I'll be out.
23rd April.
26th.
23rd April,
Please, Manoj.
Tuesday is the hearing day.
23rd.
Any day prior.
Prior to that, this view petitions are up to 17. 18, 19 are the sandwich days. 23rd is the 23rd April.
Yes,
We have BU holidays here in that
Oh.
week.
I understand.
Lordship, it could be in the first week of May, Lordship, because the hearing may take some time, your Lordship, because we'll have to go through all these petitions and along with the annexure, they are going to put this volume in it. So it may take 2 days.
7th of May. Then 7th of May,
7th of May.
इसमें आज ये
7th.
लिखवा देते हैं कि when the matter was taken up for hearing, certain discrepancies were recorded in the paper with regard to designation, arranging of annexures, which require rectification. Land Council for was that also agreed. And we are here and we requested to go ahead. You can give me that.
7th of May is okay.
Please, Manoj, I tender my apology, Manoj, for the non-pagination, Manoj. It's
During the midst of the hearing. It's so time. Difficult to.
7 May.
The second.
It's okay. No.
Second May.
Which?
I'm okay with that.
2nd May. So 2nd May is the Thursday. In fact, we prefer it to have it on Tuesday, being a hearing day. That's why only 7th May. During the course of the hearing, we found that the documents referred to by the net consent of the parties are not in order. And therefore it is difficult to find them. Full stop. The consent for the parties are in agreement that before advancing their final arguments in these matters, the correct pagination is to be done, and for that they seek some time. To stop, time prayed for is granted. List on 7th of May,
Please, ma'am.
2024 as prayed.
Please, ma'am. Malaj, can I put a small caveat? Malaj, if some documents are missing, can I be permitted to file additional?
Yeah, whatever it is, you please complete your whatever
Please.
the pleadings and
Please, ma'am.
documentation. Yes.
Grateful.
Place on record, proper compilation of paper.
And the registrar is also directed to verify and place on record the correct compilation of the documents pertaining to the writ appeals.
Please, ma'am. Malaj, deeply obliged, ma'am. Deeply obliged, ma'am.
एक ही appeal. एक ही appeal.
Appeal, अच्छा, writ appeal. ठीक है, ये वही है, बाकी few are the IAS. And all of them are- ये भाई,
Item 18.
The standing council of higher education and UGC both are the standing council of higher education and UGC both are legs in court number 2 part head matter. That is item number 1 going on, and it will take some time.
And the request of the consent with the respondent,
Yes, madam.
UGC and
Higher education, madam. Higher education.
Your lordship may fix a date, my lord.
After 2 weeks, whatever the.
A date may be fixed, my lord. Any convenient date, whatever specific,
Whatever, after 2 weeks, whatever the date
my lord,
you suggest, we'll fix that.
9th of April.
obliged.
Madam.
Item 20.
Lordship, in this matter, we've been newly engaged for respondent number 1 and 2, your lordship. We require some time to complete our instructions, lordship. May I pray for any date in the first week of April?
The appellant is still in service.
Yes, Lordship.
Still, it's the interim.
How old is he now?
Lordship is is 61 years, Lordship.
61.
Yes, Lordship.
And according to you, what is the date of superannuation?
Lordship, according to us, on the day he attains 60 years of age, lordship, he should retire, lordship.
And according to you,
It is 2025, Lordship. It's a tenure post,
4 years,
5 years.
5 years. Either or actually, either or. Or inconsistent. Whichever is the but there is a notification by developing it. They are the ones who have created. उनके बारे में तो पता था कि manually ये rules में ऐसा होना मत ठीक है तो कोई rule में कर दिया either on attending this age or on completion. This is a specific age where there is a specific appointment. The specific appointment up to 60, it's up to 60. So what is the question? It's sort of confusing. Yeah. The order of appointment is dictated. Where is the order of appointment of your client?
Not to page 55, your lordship, the reappointment notice. Subsequent appointment order, page 55.
This is a very confusing. Need a page 55. The term of 3 years, as per the first statement, in the payment of the. इसका तो specific कर रहे हैं, they should have paid. On attaining age of 60 years. He challenged that case of 60 years. After accepting this. Either or है, either or है, either 4 years, 5 years, or on 18, whichever is earlier. The matter is clear. Nuance time. What? Password was the big.
First week of April, your lordship. Any day in first week of April, your lordship. For final disposal.
On the day,
Lordship.
that's all.
Lordship.
On the request of.
You have for request the London concept of the
Respondent number 1 and 2, your lordship.
1 and 2 password for the day.
Lordship, interim may be extended, Lord.
Interim, if any to, they shall remain in currency till next date.
Password meter 11 and 12.
Yes.
My lord, my sincere apologies, my lord, not being able to present when the matters were called earlier, my lord, today. This is an inter-court appeal, my lord. The factual metrics, my lord, in gist is that, my lord, way back from the year 1993 to 1998, a series of ethnic clashes broke out in the western district of the state of Assam. Then, my lord, the government, my lord, constructed various relief camps. And, my lord, a large number of people who were affected on account of the ethnic clashes, they were stationed in those relief camps. Then, my lord, by passage of time, the government found, my lord, that keeping those persons, my lord, when of course, my lord, the violence have subsided, keeping those persons, large number of persons in the relief camps, my lord, assured a large cost on the exchequer of the state government. Government of Assam, my lord, made out a 4-phase plan. And accordingly, my lord, the persons who were, my lord, there in the relief camps, and my lord, the persons who finally could not, my lord, go back to their own place of, my lord, abode, and my lord, who could not purchase land, they were, my lord, granted a amount of rupees 50,000. And my lord, in between, my lord, the persons who were affected, my lord, on a large scale, they were granted, my lord, a lump sum rupees of 10,000 each. Now, my lord, the petitioners society, the members of the petitioners society, my lord, running more than 6,000 persons, my lord, had availed that benefit by receiving rupees 10,000. And my lord, by the time these action plans were, my lord, called out, my lord, they were not in the relief camps. So they do not qualify within the action plan set forth by the government of Assam. Nonetheless, my lord, having found that some other persons who were granted, my lord, rupees 50,000 for purchasing land, who could not go back and purchase land, the petitioners, my lord, society made a similar prayer before this honorable court. And this honorable court, my lord, by applying, my lord, the parameters laid down in the Disaster Management Act 2005, had directed the state government, my lord, to make a verification exercise and, my lord, to pay the balance amount of rupees 40,000. This is how, my lord, the matter stands.
Petitioner record আছে নাকি?
Which says के 50,000 पर देना चाहिए advance में. वो report कौन सी? कहीं तो 50,000 है ना?
उनको पूछते where is the 8-member committee's report? 8-member committee's report
Yes, my lord.
recommending 50,000 to be paid.
Yeah, my lord, that report, my lord. The speaking order is there, my lord. Lordship will find that speaking order at page 54 of the memo of appeal.
But is there any recommendation is out on record, that committee's recommendation?
No, my lord, the recommendation of the committee was there, my lord. This honorable court directed us, my lord, to produce that, my lord, report. Since, yes, my lord, but nonetheless, lordship may kindly come to page 54.
54.
54. 54 is the speaking order, my lord, which I was put to challenge in the writ petition. 54 is a fallout of that report, my lord. And that report, my lord, we could not trace out, my lord, since it was a old record, and finally it was found missing. We have lost an FIR, my lord, for,
54, yeah.
yes, my lord, and those papers are placed on record, my lord, on earlier occasions. Page 54, my lord, this is the speaking order. May I read it, my lord?
Only a rehabilitation grant for 7,955 number of families per family. Each family for the purpose of purchase land construction. So this committee has suggested that to 7,951 number of families, 50,000 rupees are to be given.
Yes.
For the purpose of purchase of land / construction of house.
My lord.
Okay. And these members of the respondent society are within this 7,951 number?
No.
These are different.
These are different. Because at that time, they were, it is our pleaded case out here. That is the disputed question of fact. They say, my lord, they are entitled. But we say that when this speaking order was passed, my lord, way back in the year 2011, at that time, they were not members of the relief camps. It was only meant for the members who were staying in the relief camps.
On 2011.
Absolutely, my lord.
So even if a person stayed in the camp up to, from 98 to 2010, he is not entitled for this compensation of 50,000. Only the person who is residing on 2011 is entitled for.
My lord.
How can it be?
Because, my lord, the government.
Ultimately, the whatever the committee has come to the conclusion that 50,000 to 2 lakhs, every person, every family has suffered a loss of this much of amount. And they have announced with that 10,000 to 50,000 every family should be paid. It is not your case that their house were not destroyed or something else. They have not suffered any loss. It is not your case. Simply because they left the rehabilitation camp and residing in their own village. Therefore, they are not entitled for that. That is absolute.
This was the policy decision of the state. Now
the policy is absolutely discriminatory.
Now lordship will kindly appreciate here. The petition members of the petitioner society, they were paid, my lord, rupees 10,000.
Only.
No, because they moved out of the relief camps. They moved out and they began to lead normal lives. That is the situation. That is the, my lord, difference between the two categories of persons. Some persons were still there in the relief camps. They could not go back because they do not.
Mr.
My
Parpujari,
lord.
please understand the query.
Absolutely.
The learned single judge has held that this was a discriminatory notification, right, and interfered with it. The point is this 50,000 or the enhanced amount of 40,000 is directed towards compensating those victims who either do not have land or have suffered losses of their property. The learned single judge says this should apply equally across the board, regardless of whether on that date the persons have returned back to their land or are still continuing in the relief camps. Because they are all equally, they are standing on equal footing insofar as the losses is concerned. So your purpose could be something else. But we will examine the matter from the touchstone of Article 14. My lord is asking a query that how do they stand in different footing? Because merely because one set has returned back, that doesn't mean they have not suffered losses.
Yes.
This is a compensation package,
Absolutely correct.
relief package.
Absolutely.
So merely because they have returned back, how can you deprive them of this benefit of this relief? That's
Yes.
the question.
Yes, now the distinction has come up because of the fact, my lord. It is not the case that none of the persons have been, my lord, compensated with money. Everybody has been compensated at least with rupees 10,000. But those persons who were still there in the relief camps, who could not go back, my lord, and purchase land, they were given a lump sum one-time compensation of rupees 50,000.
Not only purchase of land, of construction of house also.
Yes, my lord.
So if the house of a person is demolished, was demolished, and you have granted compensation for construction of house, it is not your case. Their house was not, the persons were, their houses are intact and were not demolished. This is not your case. Simply on the day when this report was there, they were not in the rehabilitation camp, therefore you are not granting that. This absolutely, there is no logic there.
The logic, my lord, this is a full-fledged plan, my lord, because these ethnic places, my lord, that spread over a period of, my lord, prolonged period of time, way back from the year 1993. And this was the, my lord, second round of litigation before the learned single judge. Prior
Here
to
the learned single judges asked them to pay this difference amount. Then you pass this order, that is.
No, my lord, this order was passed, my lord, prior to, my lord, the passing of the impugn order. This was put to challenge because absolutely correct. They have, my lord, challenged this order on the ground of being discriminatory, what has fallen from my lord. Now, my lord, these are issues, my lord, within the domain of the state, my lord, in my respectful submission, because they were large-scale violence. But we have to call out.
State has rejected here, then certainly they have no other option except to oppose this
Absolutely,
law.
Maharaj, it is my humble
Domain of the
submission.
state is right, and the state has exercised its domain, but rejected their prayer.
Rejected the prayer because of the reason, my lord, they do not come within the footing of the, my lord, those persons.
That's why that
Yeah.
is the learned single judges found that is discriminatory, that's all.
Yeah.
What's wrong with the judgment of the single judge?
Well,
We don't find any illegality.
this, my lord, otherwise, my lord, in my respectful submission will bear a huge, my lord, monetary, my lord, incurrence on the state exchequer. Number one, and number two, my lord.
Mr. Advocate, we would have agreed in the year 2011. At that time, it might have been huge amount. But now 50,000 nowadays, it's nothing. With the rupees 50,000, or otherwise, if we calculate the whatever the loss they have suffered from present this day, then what would be happen to the state government? What would happen to the state government?
Because the only parameter, as rightly pointed out by my lord, the only parameter is that, my lord, whether a person at that relevant point of time was, my lord, staying in the relief camp.
Where is the order passed in WPC 4172 of 2010?
4172, my lord. That lordship will find at page 49 of the memo of appeal. Operating portion lordship will find at page 52 and 53, my lord, the last paragraph.
Have you paid the amount?
My
The
lord,
difference amount 40,000 rupees?
no, not paid, my lord, not paid.
Is there any stay?
Yes, my lord, there is a stay, my lord. We had filed a stay application, my lord. There was some delay also. Delay was
There
founded,
was
my lord.
not, but there was no stay.
We had filed an, my lord, interlocutory application, my lord.
But no stay is passed by the court and you have not challenged that order. You have not complained about the contempt.
My lord, contempt was filed, my lord.
Then
My lord, these petitions were filed, my lord, contempt is still pending. I think.
Huh?
Contempt is my lord, still pending, I think.
still pending.
Single bench. Single bench for pending.
Since appeal has been admitted, my lord, with all respect, my lord. That is, now, of course, my lord.
After admission, the appeal
Absolutely.
can't be dismissed. No?
Absolutely, absolutely.
This is your argument. That since it is admitted, it ought to be allowed.
My lord, my humble submission is we get to stay, my lord.
Okay. Anything else?
Lordship, if my lord may be pleased to accommodate me for 1 or 2 days, my lord.
For what?
My lord, I will place some decisions of the honorable apex court because on
Which-
facts,
Which decisions? In
On-
this case, even the decisions are required.
my lord. My lord, to the extent that my lord, money will be a compensation. I will be relying on the decision, my lord, of the apex court, my
If
lord.
the state takes a decision to challenge this order, show those judgments in the appellate authority.
My lord, only 2 days, my lord, with all respect, my lord. Only 2 days.
I don't number of times, my lord.
No, only 2 days. I will place a decision
Orders
because
in
facts are
place, my
clear
lord.
before, my lord. Facts are clear.
No, Mr. Barpujari, you
My
see, financial constraint is a perennial issue, and we appreciate that. But being a writ court, we have to see the constitutionality of an order passed by the single judge. The financial constraint cannot be a ground for us to overturn a finding which is premised on a conclusion of discrimination. So since there is financial constraint, let there be discrimination. That can't be the approach of the writ appellate court.
No.
So the learned single judge has clearly found that you made a classification, and that is pursuant to the order passed in the earlier round of writ petition, where the petitioners are all those who are still residing in the camps. So the principal secretary revenue passed that order, confining it only to the people who are still in the camp, because that is in consonance with the order of the single judge, but leaving us out those who have already left. But this was the bone of contention before the single judge, wherein a conclusion was recorded that this would be discriminatory, because whether they continue in the relief camp or not, they have, both the groups have suffered loss to their properties.
Absolutely.
And this compensation package is a rehabilitation package. It is to permit the riot affected victims to start a normal life.
Absolutely.
For some, it could be that with that money, they'll purchase a land. For some, it could be construction of house. For some, the house which have already constructed or renovated, this would be a soothing balm. So we do not find any ground to overturn that finding. That's what my lord is indicating.
Absolutely, my lord. I take it, my lord, with all humbleness. So therefore, lordship, my endeavor will be, my lord, to persuade my lords, my lord, with apex court decisions that, my lord, the state can make a classification in the matter of rehabilitation, number 1. Number 2, my lord, monetary consideration will be a relevant factor. Only to that.
No, state can make a classification, but that classification has to withstand the test of Article 14.
Absolutely.
That's the point here.
Yes. Now, my lord, here, my lord, the factual matrix is that, my lord, the persons who were staying in the relief camps, persons who are not staying in the relief camps. That is the, my lord, classification the state has made here. Now, whether that is permissible, my lord.
Para number 28 of the judgment is the sum and substance. You read that para number 28.
Para number 28.
Then
May I read it, my lord? I'm so obliged. In the instant case, and as indicated above,
due assessment with regard to loss and damage suffered by the members of the petitioner society had been made by both the forest and revenue officials. The said assignments were made on account of damage to houses, cattle, etc., quantified well above rupees 50,000 per family. The loss suffered on account of destruction of property and or damage to house, etc., arising from man-made causes has to be duly compensated, which is recognized under the provisions of the Disaster Management Act 2005. In that view of the matter, the order under challenge dated 31/3/2011 rejecting the claim of the petitioner society solely on the ground that the members of the petitioner society had returned to their own villages and had been leading normal lives do not find the support of law. The members of the petitioner society are legitimately entitled to be compensated on account of damage to houses and for restoration of means of livelihood on the basis of the loss and damage assessment reports.
No, this is what we are saying.
My lord.
We are agreeing with this.
No, my lord, since we defy, my lord, so I'm making an attempt, my lord.
Vehemently, your submissions will note that vehemently you.
Lordship will kindly allow me, my lord, only with all respect, my lord, at least 1 day time.
No, sorry. Anything else? Accept that time.
Then, my lord, I will be relying on, my lord, I have not bought the decision, my lord.
Then don't rely on it. Don't draw your decision, don't rely.
My lord, that.
Yes, what do you want to say?
My lord, but we have lost suffered also, my lord, in the repetition annexure 3, they have assessed amount to 2,50,000.
Three.
Annexure 3 of the repetition.
Your-
They have not disputed that
your
we have
names
not
are
suffered
there.
loss.
Your names are there in that. Annexure 3, the names of those families.
These are there, but only, not all are not annexed, only 89 and 89, some person has been, my lord, annexed.
Page.
Is, my lord, in the repetition,
Yes.
24, my lord. They, my lord, the revenue department, the circle officer and the mandal Kanano, they have, my lord, assessed this. Page 24, my lord.
Yes.
These are the, my lord, persons.
This is the list of all these families involved in this.
My lord, all the records are with us, my lord, only few of them, my lord, I have, as a, for example, have annexed up to 85, my lord. They have assessed, my lord.
Argument, sir. Order is the.
I live as well.
Order is the.
I live.
My lord, if I may, my lord, just rely on one decision, my lord.
No, there is no question.
क्या decision? Which decision?
Yes, my lord, that is 2021 9 SCC 251.
Yeah, what is the point?
Yes, my lord. My lord, paragraph 45 and 46, my lord, I beg apology, my lord, I could not, my lord, get hold of the decision, my lord. No, that is report consult, my lord, arising out of, my lord, that COVID pandemic. COVID pandemic. My lord, I am relying on paragraph 45 and 46, my lord, with all respect. If I may read it, my lord. Paragraph 45, my lord. As observed herein above, the government has to decide its own priorities and reliefs to different sectors for different reliefs. The government is required to take various measures in different field sectors like public health, employment, providing food, shelter to common people, migrants, transportation to migrants, etc. The government is also required to deal with
the effect of pandemic on the economy. As observed herein above, a huge amount is required to be spent for so and so, even while providing minimum standards of relief. It cannot be disputed that ex gratia assistance would also have financial implications and which may affect the other minimum standards of reliefs to be provided to the persons affected by the disaster.
They can do it, but in doing so, they cannot discriminate. So it is not a case where then, the petitioners have asked to, they are simply saying that the policy is already there, they have decided to disperse compensation amount up to rupees 50,000 and we have been discriminated. No doubt about this. Yes, the government can, so far as regarding decide its own priorities in respect of relief. Once they have decided that we are granting them compensation of rupees 50,000, why to discriminate with these people simply because they left they were not in the rehabilitation camp on the particular day and therefore they are not entitled? That is that. You have already fixed your priorities. The government has already fixed the priorities and decided to compensate all the affected families with rupees 50,000. But the petitioners have been deprived of that. This is not the case. It is not the case that the petitioners are asking that formulate a policy and give us ex gratia, whatever. They have already decided.
You're also not saying that they are not affected families. That's
They
not
are-
your case.
They are affected families, but the parameter was the distinguishing factor is only, my lord, that they have left the relief camp. And it was a fact finding exercise, my lord.
Site here, reference or yeah, the photocopy.
List over.
And so obliged.